Article 153, Tumults and Other Disturbances of Public Order. The following are the acts that is punished under this article: by causing any serious disturbance in a public place, office, or establishment, by interrupting or disturbing performances, functions or gatherings, or peaceful meetings if the act is not included in Article 131 and 132, by making any outcry tending to incite rebellion or sedition in any meeting, association, or public place, by displaying placards or emblems which provoke a disturbance of public order in such a place, and by burying with pomp the body of a person who has been legally executed. So, disturbance or interruption of public order is committed by any person who causes any serious disturbance in a public place, office, or establishment, or shall interrupt or disturb public performances, functions, or gatherings, or peaceful meetings, provided that the acts do not constitute the crime of interruption or prohibition, dissolution of peaceful meetings under Article 131, or interruption of religious worship under Article 132. Tumultuous disturbance or interruption of public order. So this is actually a qualifying circumstance in this article. So it is tumultuous in character if it is caused by more than 3 persons who are armed or provided with means of violence. So arms here refers to clubs, stones, or any means of fatal violence, not necessarily firearms. So we have to note that under this article, serious disturbance must be planned or intended. And this article applies if the disturbance is not caused by a public officer, or if it is committed by a public officer, he is a participant therein. Another thing to note is if the purpose of the appraiser in causing a tumultuous disturbance in a public place is to attain a political or social objective mentioned in Article 139 and they employ force, intimidation, or other means outside of legal methods to attain such purpose, then the crime is sedition and not among the acts that is punished under this article. Now let us distinguish Article 153 from other articles. In interrupting peaceful meeting or religious worship, under Article 131 and 132, it is committed by public officer who are not participants in the meeting or religious worship. On the other hand, in 153, it is committed by private individuals or even by a public officer, but he is a participant in the meeting or religious worship which he disturbs or interrupts. Another is by making outcry tending to incite rebellion or sedition under Article 153, Paragraph 3, versus inciting to commit rebellion or sedition under Article 138 and 142. In 153, Paragraph 2, here offenders should make an outcry or display emblems or placards with the idea aforethought of inducing his hearers or readers to commit the crime of rebellion or sedition. In inciting to commit rebellion or sedition, on the other hand, is if the outcry is more or less unconscious outburst, which although rebellious or seditious in character, it is not intentionally calculated to induce others to commit the crime of rebellion or sedition. So here's the case of People versus Bacolod. The facts of this case are as follows. On 21st day of February 1948, in the municipality of Santa Fe, province of Cebu, on occasion of a dance, was held in a municipal tennis court in connection with a town fiesta. Herein accused, then a member of a PC patrol, fired a submachine gun which wounded one Consorcia Pasino, thereby causing panic among the numerous people present in the said dance, who ran and scampered in all directions. As a result, 2 information were filed against the defendant for physical injuries through reckless imprudence, and the other is for the commission of act punished under this article, under Article 153. So the issue here is whether or not the accused can be held guilty under Article 153, since he's already guilty under for physical injuries through reckless imprudence. So can he still be held guilty under Article 153? So the court held yes. In this case, it will be observed that both information have one common element. The defendants having fired up a submachine gun. The first, however, charged him with physical injuries inflicted on Consortia Pasinio through reckless imprudence. On the other hand, the second information accuses him of having deliberately fired the machine gun to cause a disturbance in the festivity or gathering, thereby producing panic among the people present therein. The two information do not describe the same offense. One is a crime against persons, but the other is an offense against public peace and order. So this case, in relation with Article 153, the act that is punished in this case is that here defendant caused serious disturbance in a public place, office or establishment, and he also interrupt and disturb performances, functions or gatherings or peaceful meetings, and it is not the act included in Article 132 and 131.